I'm very proud to welcome the stand here, our second speaker. I'm really sorry, Russell, you'll have to rush it a little bit. Russell BUCHAN is a senior lecturer at the University of Sheffield, where he teaches international law. He's actually on the verge of publishing a book on cyber espionage, on which his presentation is about. So enjoy. Russell, the floor is yours.
Thank you very much, and thank you to the organizers for their kind invitation for me to be here today. As the presentation, the title of the presentation reveals, I'll be discussing cyber espionage and international law. Cyber espionage, or cyberspace, sorry, has obviously emerged as an indispensable feature of the contemporary era. It goes without saying that in this highly interconnected and instantaneous environment, it yields considerable benefits to various state and non-state actors. But this being said, cyberspace has also emerged as a significant repository for various threats and vulnerabilities. This landscape is multifaceted and dynamic, but in recent years, the exploitation of cyberspace for the purposes of espionage have emerged as a particular concern. And various media reports and reports by cybersecurity companies, etc., reveal the scale and intensity of the threat of cyber espionage. In light of that threat, today I'd like to pursue three distinct objectives. First, I'd like to provide a working definition of the concept of cyber espionage, not least to focus the scope of my presentation. Second, I'd like to assess the role of cyber espionage in international relations, and in particular assess its impact upon international peace and security. In particular, I'd like to present cyber espionage as a pernicious practice that represents a threat to international peace and security, and which is thus in need of international regulation. Finally, and in light of this threat, I'd like to identify the international law implicated by the practice of cyber espionage and assess the extent to which international law effectively regulates and protects against, I suppose, this practice. So defining cyber espionage. According to the US Presidential Policy Directive entitled US Cyber Operations Policy, cyber espionage can be defined as operations and related programs or activities conducted in or through cyberspace for the primary purpose of collecting intelligence. So I want to pick up upon several features of that definition, which I think are important. Firstly, for the purpose of my presentation, at least, my focus will be on transboundary cyber espionage. So I don't consider, for example, cyber espionage committed by nationals against their own government. And this is an interesting question, I think, not least given recent convictions of Chelsea Manning under the US Cyber Espionage Act and the potential trial of Edward Snowden under the same legal framework. But crucially, this would be a question of national criminal law. And that's really outside of my area of expertise. Also, given the interconnectivity of cyberspace, espionage can be committed remotely by actors physically located in different jurisdictions. Now, although domestic criminal law instruments can be used in order to protect against such forms of cyber espionage. So, for example, in May 2014, the US invoked the Espionage Act in relation to 5 Chinese military officers who allegedly committed cyber espionage. But because they're physically located in a different jurisdiction, it's very unlikely that China will extradite those individuals, and thus the national criminal law of the US is going to be ultimately ineffective. Instead, we need to look to international law for protection from cyber espionage. And it's one of the important reasons that we need to continue to assess and see how international law applies in the context of cyber espionage. Very quickly, there are obviously 2 separate legal frameworks in international law, the law during peacetime and the law of armed conflict. Separate legal rules apply during times of armed conflict, and in particular to espionage. I'm not going to consider that today. It's interesting, and I would like to get into it, but time restrictions mean that I'll focus upon the legal framework applicable outside of the context of armed conflict. Unauthorized, of course, cyber espionage needs to be unauthorized in order for it to potentially run into conflict with principles of international law. Interestingly, there are various armed controls treaties that permit intelligence gathering between parties to a particular treaty. If the state parties stay within that particular framework of that particular treaty, it won't be unauthorized, and therefore isn't particularly problematic. Security Council authorizations can also authorize intelligence gathering, potentially cyber espionage, particularly during peace operations, actually. And again, if they have that Security Council approval, it won't constitute cyber espionage. State-sponsored cyber espionage. My focus in this presentation, as per the request of the organizers, is to look at the responsibility of states for cyber espionage, not the responsibility of non-state actors, which is an extremely important question as to whether or not non-state actors can be subjects and objects of international law, or whether they're indirectly regulated through the doctrine of due diligence, which has already been referred to. My focus will be on state-sponsored cyber espionage. So just I have to put in my presentation into context then. Let's move on to some more substantive issues. Firstly, I just want to briefly consider, probably a more theoretical question, but the role and nature of cyber espionage in the context of international peace and security. Well, historically, espionage as a practice was defended on the basis that it serves an important function in maintaining international peace and security. So this defense of espionage is rooted in classic realist theory. So the argument is that states exist in a state of nature because the world order doesn't possess any overarching government that's capable of protecting state security. So in the absence of centralized protection, states will themselves seek to maintain their own survival in the system. What this means in practice is that they seek to acquire material power relative to their competitors in the system in order to ensure that potential aggressors are deterred, or if that threat manifests itself, that they can be repelled. So peace and security in this realist world order is maintained through a balance of power, where there's a balance of power between states. In this context, espionage becomes really important because it enables one state to accurately determine the material capabilities of another state and take measures in order to balance that particular power. In this sense, we see the literature, dating back many centuries, arguing that espionage is crucial to the maintenance of international peace and security. There's an interesting quote there that, from that literature, which demonstrates the benefits that are accrued by espionage. However, as the point on the slide reveals, since 1945, at least, and in years following the signing of the UN Charter, and in particular as it became a universal international organization, international relations have been predicated upon the principle of sovereign equality of states. In fact, the principle of the sovereign equality of states is now a constitutional norm of international law. And the principle of the sovereign equality of states enables or permits states to determine their internal affairs without external intervention. So in this system, peace, international peace, is secured through law, not through material power. So the argument is that espionage, in this sense, can't possibly benefit international peace and security because instead it would represent a threat to a state's national security, to its sovereignty, and that in turn would jeopardize international peace and security. Now, we've seen similar arguments in relation to cyber espionage, that because of the particular practice of cyber espionage, that states have had their sovereignty adversely affected, because states continue to maintain sovereignty in cyberspace, and that cyber espionage too can threaten this particular state sovereignty. This is particularly so given that in the contemporary world order, states are seeking to cooperate on a much more thicker basis, that states are now being confronted with various international threats, such as international terrorism, environmental degradation, etc., human rights concerns, even cybersecurity, and that they need to cooperate on a thick basis in order to secure international regulation, in order to resolve these particular problems. So if this is the case, and if states do need to cooperate on this thick, trusted basis, and they do need to develop international regulation, then it seems difficult to see how cyber espionage can promote international legal development. How can states possibly create international legal rules if they don't trust other states to respect their sovereignty? In this sense, espionage can be considered to infringe upon state sovereignty, deter functional cooperation between states, which ultimately jeopardizes international peace and security generally. If states need to cooperate on this basis, if they need to address common problems, if they need to do that through international law, how can they do that if international law is predicated on the principle of sovereign equality of states, and cyber espionage violates that principle of sovereign equality? So in this sense, cyber espionage has a destabilizing effect upon international cooperation, and therefore upon international peace and security. For example, I've got some interesting quotes. As we know, in light of the revelations by Edward Snowden, the Brazilian president was due to visit Washington to discuss with the Obama administration various regional and international problems. After the release of the Edward Snowden revelations, then the Brazilian president immediately cancelled her trip to Washington, proceeded to the UN General Assembly, and gave a rather vociferous statement which denounced the destabilizing effect of cyber espionage. There's an interesting quote there. Friendly governments and societies that seek to consolidate a truly strategic partnership, such as in our case, cannot possibly allow recurring and illegal actions to go in this way. Such actions are totally unacceptable. We heard just about the Sony incident in the last presentation, and there's some interesting quotations coming from the US administration. There was a commitment of the United States to hold North Korea accountable for its destabilizing, destructive, and repressive actions, particularly its efforts to undermine US security. In particular, the White House explained that the president considered this to be a national security matter. States exercise sovereignty in cyberspace. They exercise sovereignty over information contained in cyberspace by actors within their jurisdiction. And where this is the case, and that sovereignty is violated, this does have this broader destabilizing impact upon international peace and security. Sure, there will be some threats represented by cyber espionage, that are more destabilizing than other threats. So where cyber espionage is committed against the head of state, Angela Merkel, for example, that will represent a far more significant threat than, for example, the rather innocuous collection of mass collection of various emails. But the issue is, this is my presentation, is that that cyber espionage, that transboundary cyber espionage, will still violate state sovereignty and will jeopardize and threaten international peace and security more generally. In light of the threat represented by cyber espionage, then, the next question, the important question, is whether cyber espionage is permissible under international law. Well, the starting point must be the Lotus Principle, the famous Lotus Principle dating back nearly a century, that states are free to act on the international stage, providing there is no rule of international law that prohibits such conduct. There is no specific or direct international regulatory framework relating to espionage generally, but this doesn't mean that espionage, and thus cyber espionage, exists in a legal vacuum. In fact, it's inherent in the nature of such an activity that it can come into conflict with general principles of international law. And in the context of cyber espionage, the most relevant of these seems to be the principle of non-intervention, which is well established in international law. We see reaffirmed repeatedly in various state practice, but also decisions of international tribunals, most famously the Nicaragua case, but much more recently in the armed activities case, for example. And it's well established that there are two elements in order to establish an unlawful intervention. First, the act in question must intervene in a state's sovereign affairs. Secondly, that act must be coercive. So let's take a look and to see whether or not cyber espionage, the application of cyber espionage in relation to those two principles. First of all, to this question of sovereignty and the implications that can have for the legality of cyber espionage, is that established in relation to cyber espionage? Well, we need to think about what the purpose of this criterion is. And the purpose of this criterion is to assess whether the alleged intervention pertains to a matter that is permissibly regulated by the state as part of its sovereignty, or whether international law has determined that it's a matter that falls outside of the realm of state sovereignty. And if it's the latter, then there can be no unlawful intervention, because it's not within the state's sovereign affairs. So just to put it into context, an example would be historically human rights were considered to be a matter of national concern, but more recently the issue of human rights protection has been elevated to a matter of international concern, and thus out with state sovereignty, thereby modifying and adapting the application or the scope of the non-intervention principle. So the question is whether states possess sovereignty in cyberspace. At one point in time, it was argued that, some commentators argued, that cyberspace was beyond the sovereignty authority of states, and instead information within cyberspace existed within a global commons. And this was an international legal classification that, that cyberspace was res communis. So the information in cyberspace was not part of state sovereignty, but was actually within a broader international legal category of a global commons. The briefest assessment of state practice, and I was looking earlier at the repository of documents that the Cyber Defense Center lists of the various cybersecurity policy documents by states and by international organizations, makes it quite clear that states continue to exert sovereignty over information that's resident in or transmitted through cyberspace. So, information in cyberspace is subject to state sovereignty. The second, and perhaps more controversial requirement, is that the act that intervenes in state sovereignty must be coercive. Commentators have argued that coercion is action taken by one state to secure a change in the policies of another. So in this sense, the dividing line between permissible influence in sovereign affairs and impermissible intervention in sovereign affairs is whether the act in question forces the state to act in a manner that it would not have voluntarily chosen. Now, we also see this interpretation in various academic writings and also in the first Tallinn manual. And ordinarily, such an interpretation of coercion wouldn't be particularly problematic in the context of cyber. Take, for example, DDoS attacks. They would clearly prevent a state utilizing its cyber networks, or website defacement, again, would clearly be coercive because it would prevent the state utilizing its websites, for example, in the manner that it considered necessary, and probably also communicating with its population or with external actors. In the context of cyber espionage, this narrow definition of coercion is problematic, because cyber espionage does not necessarily require the copied information to be used to impose pressure or influence upon the victim state. Indeed, in many instances, a state will be unaware that it's been the victim of cyber espionage. But this narrow definition of coercion would mean that cyber espionage is permissible. And I have a quotation from Katarina Zilowski, who's very close to the NATO Cyber Defense Center, and she explains that a forbidden intervention in domestic affairs requires the element of coercion of the other state. Scholars assert illegal coercion implies massive influence, inducing the affected state to adopt a decision with regard to its policy or practice, which it would not entertain as a free and sovereign state. And goes on to conclude that it's clear that clandestine information gathering, as such, will not fulfill these requirements. So in this sense, cyber espionage does not constitute coercion. It's not a coercive act. It doesn't impose massive influence, and thus it's not violative of the principle or an unlawful intervention. Now, for me, and I realize this may be a rather controversial perspective, I find this to be an unnecessarily narrow understanding of the concept of coercion. As I've explained, the concept of coercion is a constitutional norm of international law and is something that requires robust protection. It thus needs to be broadly defined as encompassing the capacity of a state to take decisions in an independent manner on matters essentially falling within the realm of national concern. Thus, a breach of a state's sovereignty arises where its authority and control is compromised or undermined. So the issue is whether the act in question violates the sovereignty of the state. Does it undermine or compromise the authority structures of the victim state? If that's the case, there is therefore no requirement that their influences be imposed, let alone massive influences, as Katerina explains, to be imposed upon a particular state in order to pursue a particular course of action or to abstain from a course of action, in order to fall foul of the non-intervention principle. So just to recapitulate, there isn't this requirement to secure a change in a policy of a particular state in order to be coercive, but instead that, and more broadly, that the authority structures of that state are undermined or compromised. Before I proceed, I think this is a controversial understanding of what is meant by coercion, but there is support for it. And if you look to the ICJ's decision in the Coercion case, the ICJ found that the UK violated Albania's sovereignty. That is, it was an unlawful intervention, by entering Albania's territorial sea in order to collect evidence of illegal mining. And the ICJ considered this to be coercive conduct, even though the UK's conduct did not secure a change in policy. The issue was that the UK entered into Albania's territorial sea to collect evidence to see who was responsible for the mining of this UK vessel. And we see that the ICJ determined that there to be an unlawful intervention there. In the context of cyber espionage in particular, there's some interesting state practice which has been alluded to already, and I just want to discuss briefly, because I think it gives a flavor of the way states feel about cyber espionage, and whether cyber espionage is indeed violative of the principle of non-intervention. We have China's hacking of Google, the US company, in 2010. This isn't a particularly clear or unambiguous revelation of US sovereignty, not least because of the way in which the US responded. So Hillary Clinton, as Secretary of State, produced a formal démarche, which is a recorded state protest, that China's conduct raised serious concerns. So she didn't say it was unlawful under international law, she said it raised serious concerns. But I think it gives us an understanding of how the US was perceiving that particular, or China's alleged hacking of Google in order to obtain Gmail passwords of human rights activists at the time. We also see Senate Resolution 405. Again, uses interesting language. It says that the accessing of the computer networks and the appropriation of these passwords was illegal. It didn't say it was legal under international law or domestic law, which of course is crucial. But again, I think it gives an interesting flavor of the US perspective on this cyber espionage. We have better examples more recently in relation to the US's cyber espionage campaign. I've already alluded briefly to the Brazilian president's statement before the General Assembly. And again, we can see some quite important language featuring in that particular statement. So, this intrusion and meddling in such a manner in the life and affairs of other countries is a breach of international law. Didn't identify necessarily what the particular breach was, but there's certainly an indication there, quite clear indication, that Brazil perceived the US's actions to be unlawful. It goes on to explain a country's sovereignty can never affirm itself to the detriment of another. Another interesting quote, these illegal actions prompted a demand for explanation, a demand for an apology, and guarantees that such acts or procedures will never be repeated again. And indeed, actually, the Brazilian president goes on to explain that such conduct represents a case of disrespect to national sovereignty. So there's a clear implication there that the principle of non-intervention, which protects state sovereignty, has been violated. It's a particularly important state practice in this field to support my interpretation. Germany, too, explained that these actions were completely unacceptable. Again, didn't identify a particular legal basis. This could be explained on maybe political or moral grounds, but again, does give a certain sense of the international reaction to this conduct. The hacking of Sony, to which we referred to already, again, there was no express determination by the US that the principle of non-intervention had been expressly contravened, but the US did say that it was going to take a proportional response, as we've seen. And the implication there that there was an internationally wrongful act. You can't take countermeasures unless an internationally wrongful act has occurred. And actually, Senator John McCain said that the US administration should have used stronger language to condemn the conduct, saying it was a cyber attack, an indicative cyber war, which the US president refused to endorse. So there's a suggestion there, it's implicit, as the way I see it, that there has been a violation of a particular international legal principle, and it would have to be by implication the principle of non-intervention. As we've seen in January, the countermeasures were indeed taken. An interesting case that isn't discussed hugely in the literature is the recent litigation between East Timor and Australia in 2014, where East Timor alleged that its private correspondence between itself and its legal advisors had been intercepted and sought provisional order from the ICJ, which the ICJ granted, and which determined that Australia not interfere in any way in communications between Timor-Leste and its legal advisors. And if you read the literature surrounding that case, then you will see that there's the general interpretation of this particular judgment is that the interference in communications constituted an unlawful intervention. So if the principle of non-intervention is relevant, and particularly these two elements are contravened, this is an intervention in sovereignty and it is indeed coercive, a breach of the non-intervention principle can be established. there is one further basis that I'd just like to consider, and that's the claim that there's been a customary exception carved out in relation to the non-intervention principle. So the argument is that there's so much state practice in favor of espionage and the cyber espionage that indicates that it's permissible under international law, that it's established itself as a principle of customary international law, and that creates an exception to the non-intervention principle. So there's an interesting quotation there in the context of traditional espionage, that because espionage is such a fixture of international affairs, it's fair to say that the practice of espionage is a legitimate function of the state and is therefore legal as a matter of customary international law. Well, this is all rather strange, because if you take recourse to the general principles relating to customary international law, well, there are three that I'd like to mention, and I'll finish on these. Firstly, the obligation is upon those that are alleging the right to establish it, and that comes clearly from the ICJ's asylum case. And as we know, this is a very high standard. They have to evidence significant amounts of state practice accompanied by opinio juris in order to establish a customary exception. So the obligation is upon those alleging the right. It's an important procedural point. Secondly, just because espionage is widely practiced does not render it permissible under customary international law. It doesn't render it an exception to the non-intervention principle. In order for a customary exception to form, state practice must be accompanied by opinio juris. Crucially, states overwhelmingly refuse to accept responsibility for espionage, let alone to assert the legality of its practice. So, in this sense, espionage is accompanied not by a sense of right, but a sense of wrong. And in this sense, state practice and opinio juris run in two separate directions, and arguably wouldn't satisfy this high threshold for customary international law to form. Finally, I'll finish on this point, is that we don't just need to look at state practice and those states that allegedly practicing that particular principle, but we also need to look at the broader community of states and how other states react to an alleged rule potentially emerging. As I've said already, I've cited some of the state practice in the context of particularly cyber espionage, that we can see that other states have often vociferously protested against cyber espionage and determined it to be unlawful and violative of international law. And if that's the case, then arguably that would prevent a customary international law in favor of cyber espionage from emerging. And I'll finish there. Sorry, I've gone too far.
Thank you very much, Russell, for this insightful and relevant presentation. We are running a bit behind schedule, but I think we have room for one question. So, yeah.
Thank you. The question is about to what extent, states have surrendered sovereignty in certain cases. So Article 32 of the Cybercrime Convention states allow foreign law enforcement to carry out acts in their territory in certain circumstances. Mm-hmm. One is where the data is open, let's leave that aside, but one is where the service provider essentially could provide consent to accessing that data. So to what extent, you haven't mentioned the role of service providers, those that provide the ICT infrastructure. So state A, let's say the United States wants to access data on government in Indonesia, and the government of Indonesia is using Microsoft's Azure cloud platform. Clearly, it could exercise domestic jurisdiction against Microsoft to get access to Indonesian state secrets. Mm-hmm. To what extent, and that would be lawful under domestic law, but how would that necessarily be treated under international law?
Yeah, that's a really interesting question that again relates to this idea of what's authorized and what's unauthorized. As I said at the beginning of my presentation, in order for it to qualify as cyber espionage and therefore implicate various principles of international law and for us to determine whether or not it's permissible or not, it would need to be unauthorized. So if there are issues of consent that have worked in there so that information has become available through various treaties or through various conventions, and consent is the basis of the appropriation of that information, then the initial actor wouldn't be acting unlawfully. But then presumably if that information was passed on without authorization from the host state, then it would again be tainted with unauthorization, and in this sense be potentially violative of the principle of non-intervention.
It works.
I think we're done here. I'm sorry, we're running out of time. As the master of the time, I'm really have to push it. Oh, sorry. Oh, you have the mic. Okay, all right.
Okay. No, I work for the European External Action Service. So I have a question, two questions. The first, how have to be considered by the international law cyber espionage against the European Union? That is not even an international organization, is an overnational organization. Mm-hmm. This is the first question. The second is that the European Union doesn't do any cyber espionage activity. It's not allowed to do it. But hypothetically, if there will be cyber espionage made by an international organization, how have to be considered?
Yeah, I'm very into my other areas of research. I research in the field of organizations. I mean, organizations do have international legal personality. The European Union would be one of those. And as possessing international legal personality, it becomes subject to the rights and obligations under international law. And that includes customary international law, and that would go for the European Union and the United Nations. So they could potentially, the institution of the EU could be a victim of an unlawful intervention, but also could perpetrate intervention as well, and would entail responsibility under international law. And we now have the draft articles on responsibility of international organizations, which would again indicate that these types of organizations have to make reparations or cease the unlawful act, etc.
No, because I don't understand.
Thank you, Russell. I think that's over now.
Sorry.
Here's the lovely present from the second conference.
Sorry for running.
Thank you very much again for your presentation.